Yesterday we discussed the provisions in section 154, 155 and 156. These three sections are very, very important. FIR is lodged under section 154 of the CRPC. As you know, information in cognizable case. When information is given to the officer in charge of police station, in a cognizable case, the officer in charge of the police station is bound to register the FIR. If it is given orally, that must be reduced into writing by the officer in charge of the police station by himself or by any other police officer as per his direction. Then the same is to be read over. The substance shall be reduced to writing by him under direction and be read over to the informant. And every such information that FIR, when it is reduced into writing or when given in writing, that must bear the signature of the informant. And the substance of such information shall be kept in a book which is to be maintained in each police station, in such form as may be prescribed by the state government. Again, the provision, there is a provision in section 154 that when information is regarding commission of a sexual offences or sexual offence which is cognizable, that is acid attack, this rape, outraging modesty of a woman, that is given by a woman, then in such case, this to be then the information shall be recorded by a woman police officer or an woman or any woman officer. When such information is given so if such information regarding commission of sexual offences that is given by a woman who is physically or mentally disabled person, so that is to be recorded at his residence or at a place as per her choice. Then the recording of the same is to be videographed. Then the third requirement is that in such case, the police officer shall got the statement of such person, that means the victim, recorded by a judicial magistrate under section 164. And it also requires that the copy of the information, either which is given either in orally or in written form, writing, that is to be given to the informant. So any person who is aggrieved by the refusal of the police officer, the officer in charge of police station, to register the FIR. He may file such, he may send the substance of the said report to the SP of the concerned district, and if the SP is satisfied that the report discloses a cognizable offence, that he may personally take up the investigation or direct any other police officer under his control or under subordinate to him to take up to conduct investigation, and in such case, that subordinate police officer will get power of all the powers which are available to the officer in charge of the police station in respect of that offence. Section 155 says, when information is given regarding commission of a non-cognizable offence. So when information is given to the police officer regarding commission of a non-cognizable offence, then he is not bound to register it. He is not required to register the FIR, the same as it did the same, and register the same. But here, he will enter the substance of the same in a book kept in the police station. No police officer shall conduct any investigation, shall take up any investigation in a non-cognizable offence without the order of the magistrate who is competent to try that case or to commit that case. And in such case, except the power of arrest, he cannot arrest without warrant. Where a case related to two or more offences, one offence is cognizable and the other is not cognizable, then all the offences that means the case shall be deemed to a cognizable case. 156. Police officer's power to investigate cognizable case. Any officer in charge of police station, without the order of the magistrate, but investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station, within the limits of that police station, would have power to inquire into or try under the provision of the chapter. If the court under which that particular police station is coming, if that offence is committed there and that can be tried by that court, only in such case you will investigate. For an example, there is a murder took place within the local limits of the Bhubaneswar police station, but report was given in the police station, Cuttack police station or the Madhupatana police station. There, in such case, Madhupatana police station cannot conduct investigation. Why? Because the court, that is Cuttack court, SDGM Cuttack, only has no jurisdiction to try that case because the murder took place in Bhubaneswar. So, second is that once the police officer has started investigation under section 156(1), that cannot be challenged in any court. That cannot be challenged. Will at any stage be called in question. That cannot be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. 156(3) gives power to a magistrate. Any magistrate who is competent to take cognizance of an offence, he may direct for investigation of the case. Section 157, procedure for investigation. So this section 156 declares the power of the police officer to investigate. Officer in charge of police station can investigate a case, cognizable offence, if that offence is committed within his local jurisdiction and the court under which local jurisdiction that police station is coming is competent to try. Third is that as per the direction of on any magistrate may direct for investigation of a cognizable offence to any order such an investigation as above mentioned. That is cognizable offence. So now, section 157 provides what is the procedure for investigation. Once the police officer makes up his mind or wants to make investigation in the case, as per section 156, this starts investigation. If from information received or otherwise, either from the information received or even without information otherwise, an officer in charge of police station has reason to suspect the commission of offence, which is empowered under section 156 to investigate. First thing, If the police officer receives information, either from by through FIR or through the report of somebody, or otherwise he receives an information regarding the commission of an offence and is competent to investigate, and he has empowered to investigate under section 156. Then he shall forthwith send a report of the same to a magistrate empowered to take cognizance of such offence upon a police report. Once the police officer is competent to investigate as per section 156 of the CRPC, if that information received discloses that he has reason to suspect, only suspicion is there. Not on receiving the information, if the police officer suspects that such offence has been committed and that he is empowered to investigate such offence as per section 156 of the CRPC, he shall forthwith send a report of the same to a magistrate empowered to take cognizance of such offence. Report the same means what? That first information report. That report will be sent to the magistrate who is competent to take cognizance and shall proceed in person. Then first you will send the copy of that FIR to the magistrate competent to take cognizance, and then he will proceed in person to that place, or shall depute one of his subordinate officer not being below such rank as the state government by general or special order prescribing this way. In the state of Odisha, only a police officer above the rank of a constable, that is up to from assistant sub-inspector police, can investigate. So here, either that officer in charge of the police station may proceed to investigate, or may depute a subordinate police officer, even a subordinate sub-inspector police or a SIO police, to proceed to the spot to investigate the facts and circumstances. What is investigation will be done? They investigate the facts and circumstances of the case. In what circumstances? What are the facts of the case? And if necessary, to take measure for the discovery and arrest of the offender. You will make investigation regarding the facts and circumstances of the case, and if necessary, to take measures for discovery and arrest of the offender. Either the officer in charge of the police station will personally proceed to the spot.
Sir?
Hello? Am I audible?
Hello?
Am I audible?
Sir, your voice is breaking. Sir, your voice is breaking.
Hello, okay.
Yeah.
Probably I am at a distant place.
Yeah, sir.
So in such case, am I audible?
Yes, sir. Yes, sir.
Yes. So this is section 157. You should understand. Section 156 of the CRPC empowers a police officer to investigate. Who is empowered? The officer in charge of police station. He is empowered to investigate an offence if the offence can be tried by the court under whose local jurisdiction that police station is coming. Suppose a particular offence is committed, but that cannot be tried by the court under whose local jurisdiction that police station is coming. He cannot investigate. Then, as per section 156.3, it is a very important provision, very commonly used nowadays. When police officer refuses to register a case, the victim or the complainant approaches the judicial magistrate or the sub-regional magistrate competent to take cognizance to direct the concerned police station to register the FIR, register that complaint as FIR, and to take up investigation. Most of the cases, when without giving, that is, previously I had stated you that Lalita Kumari versus State of Uttar Pradesh is the leading case in the matter till today. That means once a report discloses the commission of a cognizable offence, the police officer, the officer in charge of police officer is bound to register the case. He has no option. But
excuse me,
if you hello?
Excuse me, sir.
Hello?
Sir, actually, I have a doubt in this particular section.
Hello,
Sir, in section 157, sir, both cognizable and non-cognizable cases both can be, the police officer has the reason to suspect both cognizable and non-cognizable cases. And give the report to the magistrate.
In non-cognizable offence, when direction is given by the magistrate, he can investigate. Otherwise not. Only when there is a direction by the magistrate competent to take cognizance For investigation of a non-criminal offence, only in such case the police officer will investigate, otherwise not. Only section
No,
157
actually, sir,
says,
she wants to say, yeah,
yes, proceed,
yeah, sir, she wants
proceed.
to say that 157 is both for cognizable and non-cognizable.
Yes, sir.
How? If from information received,
Hello?
Hello? Sir, we can't hear you.
direction is given. There is not required to send the copy of the FIR to the police before proceeding to this court. Then investigation will be done. But 157 is applicable when he registers the case. Because you go through the language of the section. If from the information received or otherwise, an officer in charge of prosecution has reason to suspect the commission of offence, which is empowered under section 156 to investigate, not as per section 155. Under section 156. He served two ways investigation starts is empowered. The officer in charge of the police station is empowered. First, any officer in charge of police station may, without the order of the magistrate, investigate an offence. Because here, what it provides? 156. Since 156 is referred here, then that is not applicable to non-cognizable offence. It is totally confined
Yes,
to the
sir.
offence
Yes, sir.
that is cognizable. Now you are now clear. You go through the language of this section. What it says? Reaching to suspect the commission of offence, which he is empowered under section 156 to investigate. Under section 155, simply a direction is in there. No police officer shall investigate a non-cognizable case without the order of a magistrate having power to try such case or commit the case for trial. Only in a non-cognizable offence, suppose a complaint is made, a direction is given by magistrate to investigate. Nothing can do. So now your 157 is applicable only for cognizable offences, because 156 police officer power to investigate cognizable case. The heading of this section. You should always read the heading of this section and language. What is that? Only for, it is applicable on the cognizable offences, not non-cognizable. So here, that is, because you will not treat that non-cognizable case as an affair. That will not be registered as a case. So here he shall forthwith send a report of the same to the magistrate empowered to take cognizance of such offence, open police report, and shall proceed in person. Either he shall proceed in person or in a depot, a subordinate police officer. But to make investigation regarding the facts and circumstances of the case, and to discover and arrest the offender for this purpose. Provided when information of the commission of any such offence is given against any person by name, suppose that a cognizable offence is given, and information has been given against a person by name, and the case is not a serious nature. What is serious nature or not, that has not been provided in the CRPC. FIR is lodged in name, and it is not a serious nature. In such case, the officer in charge of police action need not proceed in person to this spot or depute a person, a deputed subordinate officer to make an investigation on this spot. So first thing, he will proceed like this, but an option is given to the officer in charge of the police station. If he finds suspicion is there, but they find that the offence is not serious, because there are certain offences which are cognizable but are not serious. Say for an offence under section 294 of the IPC, 341 of the IPC, those are cognizable offences but are not such a serious offence. In such case, the police officer in charge thinks it is not a serious in nature, he may not proceed into this spot, or depute a subordinate police officer to make an investigation on this spot. If it appears to the officer in charge of the police station that there is no sufficient ground for entering on an investigation, he shall not investigate. Second option is that if information is received, etc., he finds there is what? That there is no sufficient ground for entering into an investigation. It is not necessary to investigate. He shall not investigate. Again, provided further that in relation to an offense of rape, the recording of statement of the victim shall be conducted at the residence of the victim when there is an allegation of commission of rape, when the investigation is done by the police officer. The statement of the victim shall be recorded in a residence or in the place of her choice, as per her choice, and as far as practicable by a woman police officer, to the presence of her parents or guardians or near relative or a social worker for the locality. As far as practicable, that will be recorded by a woman police officer in the presence of her parents. If parents are not there, then guardian is not there. Or near relative is not there. Suppose unknown there, in this case, in presence of a social worker or the locality. Then, in each of the case mentioned in clause A and B, it is clause A and B. If it is not a serious in nature, the police officer will not proceed to the spot, or deputy police officer subordinate to him to investigate at the spot, or he considers that the investigation is not required because sufficient grounds are not there. If on the provision of section 1, the officer in charge of the police station shall state in his report his reasons for not fully complying with the requirements of that subsection, why he is not investigating. That is, it will also record, state in his report his reasons for not fully complying with the requirements of that subsection, and in the case mentioned in clause B means it is no sufficient ground to investigate of the said provision, the officer shall also forthwith notify to the informant, the officer in charge thinks that is no sufficient. I do not want to investigate. You will also record the reason. Both the cases will record the reason. And in case of B, then the officer in charge will notify the informant that inform the informant if any in such manner as may be prescribed by the state, if state government has prescribed any form or in a particular manner that is to be notified, the fact that he will not investigate the case or cause to be investigated. This is section 156. Now, let us discuss section 150. Report house submitted. This report which is submitted by whom? Every report sent to magistrate under section 157. 157, what report? It doesn't. That means that doesn't want to investigate, or it is not a serious enough sufficient grounds under that. Every report sent to magistrate under section 157 shall be documented and also the copy of the affair that is to be sent. So send a report of the same to the magistrate report to take on that is all that report also. Shall if the state government so directs be submitted through such superior officer or police as the government by general or special order appointing this behalf. Suppose the state government has made rule that such report as per section 157 that is to be submitted to the court is to be sent to the circuit inspector or a deputy superintendent of police. Such a rule is there. Then every such report will be sent through such superior police officer. Such superior officer may give such instruction to the officer in charge of the police station as he thinks fit. Superior police officer will supervise and he may give any such instruction to the officer in charge of the police station as he thinks fit. And sir, after recording such instruction and such report, transmit the same without delay. That will be routed to the superior officer of the officer in charge of the police station if such a rule is made by the state. Now, 159, power to hold investigation
or preliminary inquiry. Such magistrate on receiving such report. What such report? Such report means the police officer doesn't feel it proper to investigate. Either it is not a serious nature or there is no sufficient ground for entering into an investigation. 159 says such magistrate on receiving such report may direct an investigation or if he thinks fit at once proceed or depute any magistrate subordinate to proceed to hold a preliminary. This section is never followed by any court. No magistrate takes the pen to go to the spot personally to depute any other magistrate to make preliminary. But such a provision is there. If the magistrate, on considering that report sent by the officer in charge of the police station as per section 157, then such magistrate on receiving such report may direct an investigation. He may direct, no, you investigate. Or if he thinks fit, or if the, instead of giving direction, if he thinks fit, at once proceed or depute any magistrate subordinate to him. At once he may proceed or depute any magistrate subordinate to him to hold a preliminary inquiry into or otherwise to dispose of the case in the manner provided in this code. Police officers' power to record attendance of witness. This power is given to the police officer to summon a person, to give notice to a person, to appear before him, or to examine him as a witness. There is one restriction. No witness, which a woman witness will come to the police station, or if a aged person of 65 years, or a woman, or a mentally or physically disabled person, and then a 15 years, or any other male person under the age of 15 years will be required to appear before the police at the police station for the purpose of his or examination as a witness. This leading case is there in Nandini Satpathy case versus Nandini Satpathy versus P.L. Gani. That is the leading case. Still it is in force that there the ex-chief minister Nandini Satpathy was summoned to appear before the police, but she refused by as per this provision of section 160. What section 160 provides? Any police officer making an investigation under this chapter, when a police officer making an investigation,
Sir,
may
can you
by
repeat the
order in
question?
writing require the attendance before himself of any person.
Excuse me,
Within
sir.
the limits of his own or any administration. First, then you will also remember that you should remember that the police officer
Sir?
can
Sir?
summon a witness only who is residing within the local police station or in the neighboring police station. He cannot summon a witness from a far off place or the outside the neighboring police station to come and appear before him and to give his statement as a witness. Only the police officer may order by someone is not proper but be by notice by writing. Any police officer making an investigation on this chapter may by order in writing requiring the attendance before himself on any person being within the limits of his own or any adjoining police station. If that person is not residing, he is within the local jurisdiction of that police station or in the adjoining police station, then he may require such person by passing by a written order from the information given or otherwise appears to be acquainted. If that person is acquainted from the information or otherwise who is acquainted with the facts and substance of the case, and such person shall attend so required when such a notice is given you. So you should remember that police officer cannot summon. Suppose the police officer at a police station, at best he can issue someone what is not here only by order in writing require a person who is in the local jurisdiction of that police station or in the adjoining police station, say for Jagatpur or say for their Stanley, etc., adjoining police station to appear. But he cannot direct a person who is in Jajpur police station, who is in Jajpur, within the jurisdiction of Jajpur police station, to come to that police officer and to give his statement as a witness. Provided that no male person under the age of 15 years or above the age of 65 years or a woman or a mentally or physically disabled person shall be required to attend at any place other than the place in which such male person or woman is. That such male person who is below 15 years age or woman or a male person above 65 years age or any physically or mentally disabled person, he or she will be examined at his place of residence. The state government may by rule made in this behalf provide for the payment by the police officer of the reasonable expenses of every person attending under subsection 1 at any place other than his residence. If that witness comes to the police station, he attends the police station and gives his statement as a witness as per the written order of the officer in charge of the investigating officer. Then is such case who is investigating officer, not officer, police officer making investigation. In such case, the such police officer will pay his expense for coming to the court, to the police station, for TV station, at such rate as per the rule framed by the state government. Section 161 of the CRPC. Section 161.
Excuse me, sir.
What it provides?
Excuse me, sir.
When examine is a witness under section 161 of the CRPC. When a witness is examined, the statement of the witnesses will be recorded under section 161 of the CRPC. That statement need not be signed by the witness. Need not be signed by the witness. And the witness also is required under the law to state the truth. Now let us discuss any police officer making an investigation under this chapter or any police officer not below such rank as the state government may by general or special order prescribed in this behalf acting on the requisition of such case. Any police officer who is investigating the case or any police officer not below the rank of such officer as prescribed by the state government at the requisition of such investigating officer may examine orally any person who supposed to be acquainted with the facts and circumstances of the case. Who will examine? Any police officer making investigation or any other police officer as per his requisition. That police officer will be of such rank as prescribed by the state government. May examine orally any person who is acquainted with the facts and circumstances of the case. Such person shall be bound. This provision you should remember. When a person is required by the police to is examined by a police under section 161 of the CRPC, which to examine any person who is acquainted with the facts and circumstances. Such person shall be bound to answer truly all questions relating to such case put to him by such officer. Such person shall answer truly all questions, shall answer all questions put to him by that investigating officer relating to the facts and circumstances of the case that is put to him. Other than question, the answer to which would have a tendency to expose him to a criminal charge or to a penalty or forfeiture, because no person will be witness against himself. So that's why there will be no incriminating. If he is not bound to answer anything which will criminate him, which will expose him to criminal liability or penalty or forfeiture. Then a person who is examined as a witness as per section 161 of the CRPC by the investigating officer, he is bound to tell the truth. He is bound to answer all those questions truly. Then other than questions, if the answer which is given by that witness will expose him to criminal liability or penalty or forfeiture of property, then he is not required answer. Then the police officer may reduce into writing any statement made to him in the course of an examination under this section. So police officer may make there is required, but it must that the police officer will reduce the statement of such witness into writing, and if it does so, it may discussion is there. If it reduces the statement of such witness into writing, he shall make a separate and true record of the statement. Always 161 statement of the witness recorded on section 161 CRPC is to be recorded separately. Sometimes police officers record it in the case direction. That's not proper. So that must be recorded separately, in the separate. And true record of the statement of each such witness whose statement he records. Separate and true record. He will record the statement truly of each such person whose statement he records. Provided that statement made under this subsection may also be recorded by audio, video, electronic means. This provision is now included in the CRPC by amendment. What is that? In the year 2013, provided that statement made under this subsection may also be recorded by audio, video, electronic means. Provided further that the statement of a woman against one offense under section 354, outraging modesty, this, that is talking, etc., then 376A rape, or this 519 of the Indian Penal Code is alleged to have been committed or attempted shall recorded by a woman police officer or any woman officer. So statement is sexual offences, this offense against women, that is to be recorded by a woman officer or a woman police officer or woman officer. What is woman officer? Woman officer doesn't mean a woman police officer. Any woman who is holding any office in any office, her assistance may be taken. So what it says, provided that the statement of a woman, that means statement of a victim woman against whom sexual offences are committed, or this outraging modesty or 508, that is also against a woman, that is this comment, etc. 509 IPC, that is to be, if allegation has been made, then in such case, the statements of such victim is to be recorded by a woman police officer or by a woman officer. 160. Statement to police not to be signed. Again, it is provided use of statement in evidence. If I put a question, what is the evidentiary value of a statement recorded under section 161 of this chapter? I have put this question to many students earlier. In some occasions, they say this such a statement may be used to corroborate or contradict. The corroborate is only for the purpose of contradiction, never corroboration. If it is duly proved, then accused can use it to contradict something. The evidence contradicts on it can be used, and it can be used if it accused uses, then it can be used by the prosecution to explain in re-examination. They explain some materials in re-examination. Now let us see section 162. You should always remember, statement under section 161 of the CRPC of a witness cannot be used to corroborate his evidence. Only that can be used to contradict his evidence by the accused. So what is this? No statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced to writing, statement may discussion is there. The police officer, if he reduces that statement into writing, be signed by the person making it. In no circumstance, the statement of a witness recorded by the police officer under section 161 of the CRPC is to be signed by him. nor shall any such statement or any record thereof, whether that statement or record thereof, whether in police diary or otherwise, either that statement recorded separately or any statement or any record thereof, record regarding statement, whether in a police diary or otherwise, or any part of such statement or record be used for any purpose save as hereinafter provided at any inquiry or trial in respect of any offence under investigation. That cannot be used in any inquiry or trial in respect of any offence under investigation at the time when such statement was made, provided that when any witness is called for the prosecution, if that witness is called for the prosecution in such inquiry or trial, that means the statement of a witness has been recorded on section 161 of the CRPC, and he was called by the prosecution or prosecution examined in the trial, whose statement has been reduced into writing as aforesaid. Any part of the statement, very important, any part of the statement, if duly proved means the police officer who has recorded the statement, he must say something. If duly proved, may be used by the accused, and with the permission of the court by the prosecution to contradict such witness, only to contradict, never corroborate, to contradict by the accused or the prosecution with permission of the court. Prosecution can use with permission of the court to contradict such witness in the manner provided by section 145 of the Evidence Act. And when any part of such statement is so used, any part thereof may also be used in the re-examination of such witness. If any part is so used, then such part that may be used in the re-examination of witness, but for the purpose of only explaining any matter referred to in his cross-examination. Explaining any matter referred to in cross-examination. If re-examination is there made by the prosecution, that can be used only for explaining. Now you are clear that statement recorded under section 161 CRPC of a witness cannot be used only except to contradict such witness. Contradict to says when, if that it is duly proved that such a statement has been recorded, contradict either by the prosecution, that accused is not required to take permission of the court, but if prosecution wants to contradict, prosecution will take permission of the court, and in the manner provided as section 100, and when any part of such statement is so used, that means any part of such statement is so used means that is used for contradiction, then any part thereof, then any part of such statement may also be used in the re-examination of such witness. Re-examination commences only after cross-examination is over. So in re-examination of such witness, what for the purpose only of explaining any matter referred in the cross-examination, any matter which a witness has stated in cross-examination, to explain such matter, the prosecution may use any part of it, provided first it has been used for contradiction. Then only any part of such witness, instead of such statement, may be used by the prosecution to explain certain matters which has been brought in cross-examination by the prosecution. Nothing in this section shall be deemed to apply to any statement falling within the provision of clause 1 of section 30 of the Evidence Act, that is time declaration, etc., or to affect the provision of section 27 of the Act, that is leading to discovery, any fact discovery. If a confession made to police, whether it is confession or not, if thereby any fact discovery. Okay. So nothing this bar will not be applicable so far as time declaration is concerned of any statement has been recorded on the section of time declaration. No inducement to be offered. 163, it prohibits inducement, threat, etc. Because no police officer or other person in authority shall offer or make, or cause to be offered or make either personally offer or make or cause or through another person does or offer or made any such inducement, threat or promise as is mentioned in section 24 of the Evidence Act. No law police officer or other person in authority shall offer or make or cause to be offered or make any such inducement, threat or promise as is mentioned in section 24 of the Evidence Act while recording such statement. Then, but no police officer or other person shall prevent by any custom or otherwise any person from making in the course of an investigation under this chapter any statement which he may be disposed of to make on his own free will. But that means that a state witness, but no police officer or other person shall prevent by any custom or otherwise any person from making in the course of an investigation under this chapter any statement which he may be disposed to make of his own free. If a free will, out of free will, if somebody is saying something, it will incriminate him, that can be recorded. Provided that nothing in this subsection shall affect the provision of section 4 of section 100, subsection 4 of section 164, that is confessional statement. That will not, provided nothing in this section shall affect the provision of subsection 4 of section 160. Recording now section 164 provides recording of confessional statement. Let us conclude. In the next class, we will discuss a very important provision, that is recording of confessional statement of the accused and the statement of a witness.